the law.
I want to go to former Justice Department Attorney John Yoo, who defended his role in drafting the Bush administration torture memos. As I said, we did invite him on the show. He declined, but he did have a debate with you, Ken Roth, on the Charlie Rose show, where he defended the use of aggressive interrogation techniques.
The laws of war are enforced. You know, the laws of war where we treat each other's soldiers, given prisoner of war status and so on, are enforced by reciprocal treatment. And that's the idea that if we treat
when you have two nation states.
Yeah, exactly. And so that's the problem, is that we are fighting an enemy that is not a nation state, either in Iraq with the insurgency or Al-Qaeda throughout the world. They do not provide people with POW treatment. They don't have POW bases. As far as we can tell, they don't take prisoners or they behead prisoners. And so the question is, what is the benefit that we're getting in this particular war by providing POW treatment or providing them with the kind of treatment we usually reserve for nation-state regular armed forces, when if you use this other standard that we can give them under the law, we have the possibility of getting more information through aggressive interrogation techniques that could stop a future attack on the United States.
What's the answer?
In the same interview, you claimed Israel had decreased suicide attacks by using enhanced interrogation techniques.
The Israeli Commission found that the use of these kind of aggressive interrogation techniques went broader than it was authorized for. They also found that a high percentage of suicide bombers are stopped by information gathered from these kind of interrogations.
Kenneth Roth, your response to John Yoo's assertions that America's enemies are not nation states, so they're not entitled to certain protections, and the assertion that torture ultimately works.
Well, John Yoo is confusing two different issues. He refers to prisoner of war status, which indeed is reserved for conflicts between governments that respect the Geneva Conventions. But the prohibition on torture transcends that. That applies to any prisoner, whether a POW or a terrorist. If you're in war, or for that matter, if it's a regular criminal matter, no one can be tortured. That is an absolute prohibition that has nothing to do with reciprocity. Now, as to the argument that torture works, I mean, we heard this most recently with bin Laden's killing. You know, Cheney got on the air and said, aha, it was because of the enhanced interrogation techniques. But if you look closely, even at what Cheney says, he never claims that it was the torture or the enhanced interrogation technique that produced the information. He would say, you know, prisoners who had been subject to this helped in the capture of bin Laden. And indeed, when you start looking more closely at the evidence, it turns out that Khalid Sheikh Mohammed, who of course was tortured 183 times under waterboarding, he lied about the key courier who ended up leading to bin Laden. So even somebody who was subjected to these extreme forms of torture didn't fess up the truth about what was going on. And if you talk to the professional interrogators, they will say that it's far more effective to build a rapport with a person under interrogation, and that kind of voluntary cooperation is a much more valuable form of cracking these secretive criminal conspiracies than twisting somebody's arm or subjecting them to waterboarding.
Professor John Baker.
Well, on the first point, I agree with Mr. Roth that there is certainly a difference between the treatment accorded under a treaty as opposed to the torture provisions in our statute and well as the convention. And yes, there is a prohibition against torture of anybody. But again, we come back to what is torture. And Mr. Roth simply took the argument and expanded it. I've never argued that it is a general defense for everything. As Mr. Roth should know, if he was a former prosecutor, then when we look at self-defense or defense of others, it always depends on the particular circumstances. And if you read those memos, the circumstances were laid out, and carefully in the memos they say, assuming that these are the facts and that these are only the facts and there aren't any other facts, and if the facts change, then it's different. So contrary to what Mr. Roth says and what many law professors believe, many who haven't read the stuff or who don't teach criminal law, there is a plausible argument in these memos. You may disagree with the argument. Lawyers disagree on all kinds of things. But to simply blanket and say that this was clearly torture, to me, is nonsense. It's simply not good legal argument.
Ken Roth, I wanted to follow up on another point in your report, encouraging other countries to prosecute U.S. officials if the U.S. is not going to prosecute their own.
Yeah, well, this is a serious problem. The United States regularly pushes other governments to prosecute their torturers, their war criminals. But when the U.S., as perhaps the most visible nation in the world, doesn't abide by that same standard, it not only undermines U.S. credibility as a proponent of enforcing international human rights law, but it also sets a very visible negative example. I had this experience. I met a couple years ago with the Egyptian Prime Minister at a point where we had just received evidence that a bunch of suspects, terrorism suspects, had been picked up and were being tortured. And I met with him in his office, and I pressed him to stop it. And without skipping a beat, he looked at me and said, well, that's what Bush does. And now that's a cheap answer. We all know that. But it's a politically effective answer. If a government as powerful as the United States is flouting its obligations to prosecute torturers, why do we expect anybody else to do that?
Should it be taken to the ICC, the International Criminal Court?
Well, unfortunately, the International Criminal Court doesn't have jurisdiction over most of these cases. The only way it could get jurisdiction would be for the UN Security Council to hand it jurisdiction, and that's not going to happen with the U.S. sitting there and exercising its veto. So as a practical matter, we have a strong preference for domestic prosecutions. I think for Obama to live up to his obligation as prosecutor-in-chief and to authorize Attorney General Eric Holder to pursue these investigations, that would be the preferred model. But if that doesn't work, the only real alternative is for other governments to prosecute under their power of universal jurisdiction. This is what Spain tried to do, and the Obama administration stepped in and stopped them.
And we know that from the WikiLeaks documents, that trove of documents that are slowly being released. Julian Assange, as we speak, is in court. The significance of WikiLeaks for Human Rights Watch in gathering information, can you talk about that?
Well, I have to say that the massive WikiLeaks leak largely confirmed what we already knew. It was, I suppose, surprising to see that these State Department memos were reasonably well written. They were insightful. Their analysis wasn't that far off from the analysis that Human Rights Watch researchers on the ground were providing. So I didn't see any great insights provided by the vast bulk of those documents, other than a kind of a reconfirmation that U.S. embassies are sort of seeing things as we see them. And the real issue is, what do they do about it? Sometimes they are pushing to protect human rights, but too often they're not.
Final word, Professor Baker.
Well, a couple of things. First of all, as to foreign leaders accusing us of ignoring torture, it's because people like Mr. Roth are accusing people in the United States of torture when, in fact, the issue is whether there was or wasn't torture. Secondly, this idea of universal jurisdiction in international law is highly controversial. Indeed, if there's universal jurisdiction, then there's nothing left to sovereignty. If every country can extend its police powers beyond its borders, that's a prescription not only for chaos, it's actually a prescription for war.
A final question from what Professor Baker said, and this is to Ken Roth, when he said, well, then you should be looking at President Obama and their drone attacks killing civilians in Pakistan. What about that?
Yeah, well, the drone attacks, the Obama administration says, are attacks on combatants. In war, you can shoot at the other side's combatants. It's very different from torturing somebody in custody. Now, Professor Baker says, oh, maybe there's a self-defense argument. Let me say that there really isn't under any reasonable definition. But, let's bring that to a jury. The evidence is overwhelming that senior Bush officials authorized torture, more than enough for Eric Holder to prosecute. If Obama would just let him do that, he should.
We'll leave it there. Kenneth Roth, Executive Director of Human Rights Watch, and Professor John Baker of Louisiana State University Law School, Professor Emeritus there. This is Democracy Now! Stay with us.